I can use from the language of Channel 1. So the official language Slovenian is now off, and I'm going to switch to the second official language of this conference, which is English. And in fact, yes, this reminds me on a conference which was held 100 years ago. It was the first Pan-Slavic conference, where the first question on the agenda was, what will be the official language? And the Slavic language that was chosen then was the third language, it was German. But now, seemingly, I'm just trying to see how many of your earphones are being used. The English is kind of getting a little bit in advance for German, although I don't know how many of you would need to use your earphones if I would be speaking my own language. But, well, we can do it outside of this. I have been kindly given a very easy title and a very easy topic to present to you today, and it is a topic about Croatia and its way to the European civil procedural law. And, well, it is an easy topic, in fact, because I can close it very quickly. In fact, I can tell, well, we are still not in the European Union, and therefore we have no European civil procedural law still in effect. Thank you very much. This was my presentation. And I think it would perhaps be nice to stop here, because I think we are running out of time anyway, but I will still, especially because of my high esteem for the organizers, give a little bit more of the introductory comments. And yes, some things are rather well known to all of us from Croatia, but as we don't have many of Croatians here, perhaps I can just recount what has been going on in the Croatian way to the European Union. And what you can see here is that the negotiations have actually been opened quite some time ago, in 2004, when the opinion on Croatia's application was launched. And then we had, well, one of the longest negotiations in European history, negotiating about 35 chapters, 33 substantive and 2 formal chapters. And the last closed chapter was, interestingly, the chapter which also has to do with the topic of this conference, that was the chapter on judiciary and human rights, chapter 23 in that process. And, well, the signing of the accession treaty is something what has been scheduled now fairly soon, less than a few weeks from today, on the 9th of December 2011 in Brussels. It is being foreseen that Croatia will sign the accession treaty, and the accession foreseeable should take place on the 1st July 2013, when Croatia should become 28th member of the European Union. So this is about Croatia's way to the European Union. Let us see where we stand when we come to the European civil procedure. And, well, what shall we take under the notion of the European procedural law? And let me get back to the basics that are very well known to you, the basics which define what European procedural law is under the founding instruments. As we can see, there are some areas which are being covered, like judicial cooperation, like the proper functioning of the European market, and the cross-border implications. And you know that this general frame is something what has to be cumulatively fulfilled in order to speak about the procedure which is in the competence of the Union. And within that, well, we have several areas. First, service of documents, taking of evidence, recognition and enforcement, and all of them do take place in the context of, let's say, the stronger jurisdiction, the law that can be improved and simplified. The second level is the level of promoting the compatibility of the rules. And here we have conflict of laws and jurisdiction, and we have then the third element, which is the weakest link, how to eliminate obstacles to the good functioning of civil proceedings, where, by the way, we have the notion of promoting the compatibility of the rules of civil procedure. Some of my colleagues will speak more detail about the other topics. What is of my interest is only this, how to promote the compatibility of the rules on civil procedure. And therefore, when I speak about the European civil procedure, I will try to speak a little bit broader about that concept. Now, let me give you again a Croatian view, but starting with a Dutch citation. The question is, what is the way of implementing civil procedural law? And I have quoted here a statement by a very knowledgeable Dutch colleague, Mirjam Freudenthal, who said that as a rule, the law of civil procedure was and still is considered to be closely connected to the forum and the forum state with its own cultural and traditional specific aspects, and therefore not fit for harmonization. And this is a statement from 2003. Perhaps some of you would today disagree with that statement. On my part, I can say that I don't see a big difference from a situation in 2003. What is being permitted as the implementation of common standards is something what we can call the soft methods. Well, what does harmonization in this context mean? What should we harmonize? Is it the procedural law, or is it the procedure? Shall we harmonize just the rules of law? Shall we just put a kind of a new suit on our body? This is different. Or shall we take a look at the underlying routines, underlying practices, and see how much harmonization we have there? So the two areas that I'm going to address here is not only how to implement European law, but also how to create the European civil procedure. And I'll get back now to my own territory, to Croatia, and I will show you how the methods of harmonization with the European standards have been going on in my country in the past 5 or 6 years. As in many other countries, the word Europe still has this magical connotation. It is the European spell that we are speaking about. And, well, I was just asked again by Professor Jelinek about how likely it will be that Croatian population will support entry into the European Union. And although it is not as enthusiastic as it was some years ago, I still think that most people will have a mildly positive attitude towards it. Well, what was happening in our parliament? Again, harmonization under domestic notion of Uzelac was something that was used in the past 5 or 6 years as a kind of a legislative panacea. Whenever you cannot make some of your legislative ideal come into effect because it's well, too problematic or it is controversial, you will put a European label on your law, and that law will then have an option of a shortcut, of a fast-track proceedings, because in fact, whenever a law would get the label of usklađivanje, it would be only a single-track proceedings, only one reading in the parliament. And by the way, in the parliament, whenever somebody would ask a question, the reply would be, it is what the Brussels has required from us. So in fact, many of the laws have been prepared rather in the close consultations in Brussels than in a comprehensive debate at home. Some political debates still did take place, but I can guarantee you that, at least in the area of civil procedure, no broad discussions among the domestic experts ever did take place or were conducted. Now, what is the result? We have really passed a number of laws. It was a kind of a quantitative approach. The more laws you pass, the better you are. And in fact, that was the argument that also worked, seemingly, with our European partners. Because the European delegation always wanted to see that we are doing something in approaching the European standards in a number of fields, including the functioning of civil justice. And, well, the result was the law, next law, third law, and so on. In fact, domestic legislation became a kind of a matter of foreign policy. Yeah, sometimes speaking to some of my colleagues, I argue the point that Croatia does not anymore have a Ministry of Justice because the Ministry of Justice has been turned into Ministry of Foreign Affairs. So we have two Ministries of Foreign Affairs, but no Ministry of Justice. That's not what my colleagues in the Ministry of Justice like, but I think we can speak about it. Well, I will only give you a couple of illustrations how this total makeover of legislation, and in particular procedural legislation, was happening. And what you see here is the original excerpt from the ambitious plan of harmonization of legislation of Croatia with the acquis for year 2008. And what you will see is just the list of some laws, and you will see here the figures. Under 14 is here at the end, but I have only cut out from that list some of the laws that deal with the matters related to civil procedure, or actually with the civil procedure itself. What we see here on the list is the Legal Aid Act, the amendments to the law on courts, the amendments to legislation on lawyers, on ombudsman, Enforcement Act, Code of Civil Procedure, law on bar exam, anti-discrimination law, general administrative proceedings law, and also some other procedural laws related to contacts with children and the parental responsibility. That was in 2008. Let's get a little bit faster and see what is in 2011. Again, we see a list of laws here. Inter alia, law on mediation. Again, law on courts, seemingly we have to keep on going with the changes of the same laws. Law on state judicial council, law on state attorney's office, bar exam again, lawyers again, administrative proceedings, and so on and so forth. So it may be a little bit interesting to note that while we have seen in one of the first slides that the notion of European procedural law is rather thin, is rather, let's say, still limited in its reach, within the context of the EU negotiations in Croatia, we had to rethink a number of our basic acts on organizational, both organizational and functional procedural law. And of course, you can see that a number of those areas are not covered by the formulas from the European treaties. But in fact, yes, the rule of law, the good functioning of civil procedure, as it was mentioned in the treaty as well, is something that is of importance. Also, not only in cross-border, but in the internal functioning of the country, in the notion of the same area of liberty and justice. So, let me get back, because we are running quickly out of time, to some examples. And yes, speak about methodology in respect of the Code of Civil Procedure. I will give you an example of the coming into effect norms. We have a number of areas now in the Code of Civil Procedure. And I'm very sorry, but seemingly we have some problems with this computer. But I will give you the examples from amendments 2008 that have part 4 devoted to European civil proceedings, which have enacted a number of regulations, including the ones on the service of process, evidence, payment orders, and small claims, in a separate chapter. And then we have another set of amendments from this year that have inter alia, also in the context of EU accession, included the provisions on audio recording of the court hearings and some general norms about collective redress or associational claims, the Verbandsklage. And, well, what is interesting is that, for instance, in the amendments 2008, the general provision was, yes, we now have all of these in our law, however, it will only come into effect when Croatia will become the member. So we have a number of, well, let's say, wishful thinking related norms in our legislation, which will eventually get noticed by the practice when, hopefully not if, Croatia becomes a member of the European Union. In our tradition is that the lawyers and judges take a look at, in some law, about 6 months to 2 years after it has come into effect. Now, we have something that is already in the law but is not applicable, and therefore I can guarantee you that most of people in practice have hardly noted that something has changed. Interesting new approach. Again, you don't see in the European Treaty any provisions on audio recording of court hearings, but it has been enacted under the label of EU accession, however, with a specific provision on coming into effect. It says that provisions on audio recording will become effective when the Minister of Justice so declares, based on the finding of the court president that the conditions for recording are ripe in a particular court. Well, what does it mean? When are the conditions ripe for recording? When nobody is deaf and dumb? Or when there is something to be recorded? Or that you have a tape recorder? Well, the idea was pretty unclear until it was revealed in some private conversation that the legislator wanted to start a European project which will ask for irreversible donation of funds for the audio recording equipment. And therefore we have actually started to go into our European future with a kind of a Greek approach. Anyway, I have already started to do a kind of an evaluation, and I'm trying to go as fast as I can. So what can we say about our way to the European civil procedure? Perhaps the preliminary question that one should ask is how important is currently the European law of civil procedure for national procedural law? And to answer this question, in fact, we can deal with a number of possible approaches to see how important are the rules of European civil procedure for legal practice, how important they are for the development of law or doctrine, and how important they are in the context of EU integration. And many of these aspects, in fact, we have a number of problems, because in practice, for instance, very few practitioners, be it in Germany or the Netherlands or in Spain, really feel European procedural law in their everyday practice. I have just been in a conference with some Dutch notaries who were asked by Croatian notaries, well, how about this European instrument? And they said, never heard about it. Doesn't play a role in our daily practice. Well, of course, there is a very good reason to deal with European law, because after all, European Union is providing funds for nice conferences like this one, and we should all be very grateful for this nice opportunity. However, if we take a look at this question and try to get a little bit further with it, and you see the harmonization of IT equipment is seemingly not at the level at which I can show you the last assumptions, but in practical use, I want to cite a saying which has been used in the paper of Sandra Kramer from the University of Rotterdam when speaking about, yes, this is perhaps a good idea, if somebody is helping me with. Let's get it. Well, the proof of pudding is in the eating. So, are we eating the European pudding here in Slovenia, here in Austria, or is the pudding just a little bit bitten, or perhaps intact? The use of the European enforcement order, European payment order, and so on, is still in a number of jurisdictions quite negligible. However, when it comes to Europeanization of civil procedure, then we have some problems with national systems which still have little common grounds and many national peculiarities. What has been argued by Madam Kramer inter alia was that still achievements are that attention is paid now to civil procedure at the European level, and the rise of comparative legal research is happening. It leads to some progress at legislative level, not so much in practice, but a set of information like those collected in Judicial Atlas of Europe, European Judicial Atlas, are currently making us well aware of the European requirements. Okay, let me try get to the next one. Yes, thank you. Well, and now getting further, again to Croatian area. Let me try to do the same trick again. Yes, now it works. Okay, we have legislative implementation of the rules of European civil procedure in our law. But what I have to argue, unfortunately, is that our way of implementing the European rules has not contributed much to the national doctrine or practice of civil procedure. Even when we take a look at the rules themselves, they can speak more about the emerging double standards of proceedings. Their practical relevance so far, of course, does not exist. But it's interesting to see that our ministry has opted for a rather conservative approach. For instance, in all of the options, when some of the regulations were enacted, the options were always pointing to the most conservative point of view. For instance, the language issue. We are not alone there. I think Slovenia has the same approach, as a number of countries have the same approach. But if we want to speak about the European civil procedure, perhaps we should, again, take a look at the list of languages that we speak here in this room. And by the way, yes, in France, now they have opted in a rather, let's say, proud francophone territory that the enforcement regulations and orders can be supplied in French, English, Spanish, and Italian. I think Finland enables the supply of forms in, was it Finnish, Swedish, and English. And this is perhaps one of the ways to let's say, a European procedural future, but in Croatia we have always opted for the most conservative approach in respect of language and also methods of communication. For instance, no electronic service of process, no use of email in communication, and so on. And I find it as a kind of a problem, but it is in the context of the role of legislation, and the main role of that legislation was just to get a ticket for joining the European Union. However, there is the bright part, and this is the hope. It is the hope that still the European procedural regulations and other instruments in the area of European procedural law will contribute to what we can call a creeping harmonization, in particular because our professionals will get exposed to an international environment. They will have a duty to inform and report. And, well, there may be some eye-opening encounters with approaches that may question local procedural prejudice. And I will just give here some examples of what I think underneath that. In these territories, and I refer here to former Yugoslavia in particular, we have almost forgotten our procedural past. Bagatellverfahren was one of the origins of the modern civil procedure. However, today, in Croatian courts, you cannot know which case is a small case and which case is a big case. And we are very, let's say, traditional in the approach, meaning that even the smallest case has the same meticulous intention to find the facts accurately to the last possible detail, as one of the British observers stated when observing the work of the Zagreb Municipal Court. Oh, what you want is to leave no stone unturned, meaning that a very small case would be very detailed, but also very ineffective. Small cases, also cases of that related only to possession, they last for years and years. And therefore, perhaps now, faced with the new regulations on small planes, we will for the first time be able to harmonize our concept of small plane and then perhaps get into the direction of the currently most innovative procedural practices in Europe. And under these concepts, I think about all the principle of proportionality that was underlying the Lord Wolf's reforms in the United Kingdom and has been accepted and embraced now in a number of European jurisdictions. Payment orders. In Croatia, we have undertaken a number of reforms in the area of payment orders, but all these reforms were getting further from our European let's say, environment, because we have feudalized the payment orders by giving them to notaries and now public bailiffs, instead of centralizing them and using the best European practices like the Austrian Marktverfahren. Perhaps now in the context of Europe we will do the same what Slovenia did with the Zovel, with the Center for Enforcement of Authentic Instruments. And this will perhaps have an important use. And, well, last but not least, we all here have a rather outdated and antiquated idea about what the constitutional right to appeal should be. And here, just taking a look at the European regulations, which originally thought that in small claims there will be no appeal, just like in a number of other European countries. This is something that will help us to question our procedural prejudice and perhaps in the future embrace a somewhat softer approach. So let me conclude here. Yes, European civil procedure is important. However, the effective harmonization of civil procedure in Europe is now not happening so much through Brussels regulation, but through other terms. For instance, the already mentioned notion of the right to a fair trial and the practice of the Strasbourg Court, I think, had much more important influence on changes in judicial practice, in changes of civil procedure in practice in Croatia, but also in Slovenia. So far I can follow the Slovenian situation. The international efforts to secure at least remotely compatible standards of efficiency of legal protection in a number of jurisdictions have contributed greatly to some sorts of harmonization, and also the collection of comparative data on functioning and efficiency of the justice system is now helping us to set the idea about our differences correct, and then perhaps in the future address our differences. I hope that comparative research will also contribute to that as much as the legal transplants, which are still in a number of countries that belong to the transitional area, more used than the, let's say, formal embracing of European procedural law. And finally, some practice, some spillover of practices is being noted also in the area of international arbitration and international tribunals, where we have all learned in the last years about some notions which were until relatively soon unknown to us, like the notions of collective redress, amicus curiae, and so on. And they are slowly also being transferred into our procedural orders. And yes, all of that together with the European procedural law, which is now being still in a relatively young phase, we will hopefully all go together in a bright European future. And this has to be thank you, so I thank you very much for your attention.